Mr. Ellison argues that the difference between the auction price and the assessed price constitutes an excessive fine. I think he has a point. After all, should the failure to pay an alleged $2,200 tax come with an $118,000 fine? I don't think so. I think a better argument is a violation of the 5th and 14th Amendments due process clauses, which both read, "No person shall be deprived of life, liberty, or property without due process of law." Justice Jackson raised the point when questioning Mr. Ellison.
Can I just follow up on that? Because I'm wondering whether or not that kind of concern doesn't ring more in like a due process claim rather than just compensation. Because to the extent you're arguing about, or your claim is that they needed to do other steps before they took the property, I didn't understand the takings clause to be concerned about takings deprivation, that the takings clause was just about just compensation. And so wouldn't you be needing to bring a kind of a due process type claim if you're complaining about the personal property aspect of this?
We would acknowledge that due process comes awful close in the just compensation world, but the question that's being challenged here is, does the result of this foreclosure process result in just compensation?
Yes.
There's still that problem that Union Township did not take Mr. Punk's property for public use, but to pay a public debt. Can a government take a person's property for failure to pay a public debt? Yes, but they have to follow due process, which is defined as an established course for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. Did the Union Township safeguard the legal rights of Mr. Pung when they foreclosed and auctioned off his property for the tax they allegedly owed? Justice Alito asked about the question of the consequences of not paying taxes. But as Mr. Ellison pointed out in response, Mr. Pung did not owe taxes because Ms. DePriest retroactively denied a tax credit for 1 year after the credit she was forced to reinstate. And she allegedly entered foreclosure proceedings without sufficient notice of the ex post facto denial of the credit. So whether or not Mr. Pung actually owed any taxes should be questioned. Mr. Nelson, defending the foreclosure, stated,
after the property is turned over now to the county, who is the respondent here, when it's turned over to the county has no authority to say, now this tax should not have been paid, unless what happens is...
Oh, goodness. Really?
Unless
nobody can say, hey, there was a mistake.
Well,
I have to foreclose on someone's home for a tax bill I now know is false, but I'm forced to do it.
Oops. The county has to foreclose on a property for a tax bill they know is false? That doesn't sound right. Mr. Nelson argues that Mr. Pung had the opportunity to challenge the tax bill in court.
Your Honor, the petitioner here had the opportunity to come to the show cause hearing or the foreclosure hearing, the show cause hearing with the treasurer, or the foreclosure hearing with the court and say, this tax was never properly assessed. At that time, there is an opportunity to say the tax is not properly assessed. We're going to go ahead and reverse this whole process, and we're in the clear. But that didn't happen.
I wonder why Mr. Pung or his attorney didn't attend either hearing. I couldn't find anywhere in either of these oral arguments or the petition for certiorari where these hearings were mentioned. I wonder, since there was a hearing on the revocation of the tax credit for the previous years, was there a communications breakdown? Was Mr. Pung given proper notice?
Well, I think what the facts of this case show is that Mr. Pung was given notice of the delinquency. I mean, he face-to-face was told by the township assessor that he owed the tax.
And he went to tax court, and the tax court said, no, you don't. And he presented the government with that notice, and the government said, bye.
Right. And I think this is an unusual feature of this case, that while Mr. Pung did appeal the denial of the principal residence exemption as to certain years, he didn't appeal that denial as to the year at issue here.
Could it be because Ms. DePriest didn't deny the exemption until after the tax court told her no on previous years? What changed between 2011 and 2012 that a court would find sufficient to allow the denial to stand? Nothing I saw.